Oh, good morning. That's Senator Gallagher, is that correct?
That's correct.
Excellent. Thank you very much. My name is Gillian Triggs. I'm the President of the Australian Human Rights Commission.
Thank you.
And can I also introduce my colleague, Ms. Helen Potts?
All right. Now, would you like to make a brief opening statement before we go to questions?
Yes, you have our formal submission, but I just would like to make, if I may, just a short statement that really encapsulates the arguments that are in that fuller submission. Firstly, can I thank you for the opportunity to appear before the committee and to appear by phone as I am. May I also say that the Australian Human Rights Commission fully appreciates the importance of Australia's participation in the treaty-making process. As a nation with a relatively small population, we benefit from the international system, where interaction among nation-states takes place within a framework based on fair and transparent rules, as agreed in treaties. The Commission recognises that bilateral and multilateral treaties are an important part of our domestic agenda, foreign affairs and international reputation. But we are concerned that many treaties are not always understood as having a human rights implication. Hence, the potential for a treaty to constrain the protection of human rights may not always be recognised. I should also like to note that at the Commission, we believe that the treaty obligations, periodic reporting processes in human rights treaties do come within the concept of implementation of a treaty. And it's from this perspective that I'd like to make three brief points. The first is that the national interest analysis that we currently conduct includes a consideration of the human rights impact of the proposed treaty, and that this analysis is then tabled in Parliament along with the treaty itself. Many treaties require a legislative response under our constitutional system for them to be implemented and to implement part or all of the obligations. A draft bill needs to be accompanied by a statement of compatibility with human rights. However, this takes place at the secondary stage, the treaty having already been ratified. We're suggesting that consideration of human rights should take place at the primary stage through the inclusion of a human rights analysis with the national interest analysis, and that it be tabled in Parliament along with the treaty itself. The second point is that we consider that there should be a more systematic approach to preparation of ongoing treaty reporting obligations. Human rights treaties have continuing periodic reporting obligations to the UN treaty monitoring committees. These committees then provide a follow-up to that periodic reporting in the form of concluding observations. But as you will know, we have a three-part process here in relation to 7 key human rights treaties. So the International Covenant on Civil and Political Rights, the Convention Against Torture, Convention in relation to children, and the Convention on Disabilities are all handled in terms of reporting responsibilities by the Attorney General's Department. But the International Covenant on Economic, Social and Cultural Rights, along with the Convention Against Racial Discrimination, their reporting obligations are handled by the Department of Foreign Affairs and Trade. And finally, the Prime Minister and Cabinet deals with all matters relating to the Convention on the Elimination of Discrimination Against Women. We'd suggest that this can become a very confused and resource-intensive exercise that could be performed much more efficiently. And the United Nations has proposed that state parties establish a national reporting and coordination mechanism to provide more systematized and centralized approaches to reporting. The Commission supports this proposal and suggests that such a mechanism might take the form of an interdepartmental committee with clear terms of reference and supported by a secretariat. The third and my final point concerns the UN Treaty Monitoring Committee's follow-up to state party reporting. The follow-up includes the UN Committee's concluding observations on implementation of the relevant human rights treaty in country. Currently, there's no mechanism to ensure that concluding observations are reported back to the Australian Parliament. We suggest that tabling these documents in Parliament would place them on the public record and enable an open, transparent debate on implementation within Australia. And that concludes my opening statement. Thank you very much, Chair, and we're very happy to take any questions on our submission. Thank you.
Thank you very much, Professor Trigg. I've asked this question of all the witnesses appearing. We have been making treaties as the Australian government of both persuasions for a very long time. Is there anything that is coming into your area of expertise in the last 10 years thereabouts in these new agreements that is substantially different to the work that would have been done by your predecessors?
I'm not sure that I fully understand your question.
Well, my point is...
Are you asking what would be different from how we've responded?
My point is quite simple. I've asked everybody who's given evidence whether there is any change in the agreements that are currently being made. Is there any new issues, new items, a difference in the scope of the treaty that affect the way you do your work or your predecessors did their work? Because we have been making treaties for 100 years. Why is there a need now to look at things differently?
Well, we would suggest, and this does require, if you don't mind, a slightly long answer, but I hope it's helpful, and that is that Australia has a fairly unique approach to the implementation of international treaties in relation to human rights. And that is that while we have been very actively engaged in negotiating the treaties and ratifying them, we have, in very many cases, not implemented them in domestic law. And we would suggest that the position is becoming more serious for Australia in that we are exceptionalists relative to much of the rest of the world in failing to implement those treaties and failing to ensure an open process for reporting in relation to them. So I think we would say that it's a concern we've had for a long time, but the concern becomes greater as the practices of comparable legal systems become so much more linked to international treaty obligations as implemented by domestic legislation. The other point that I'd like to make is that many countries in their trade agreements include a social or human rights clause, and Australia does not do so. And one example that might illustrate how this could be damaging to Australia is that you may be aware of the litigation concerning our plain packaging legislation for tobacco products. Now, the failure to have any kind of protection for health in the bilateral agreement with Hong Kong could very well lead to difficulties in the longer term. Whereas, for example, the World Trade Organization has a specific clause which protects health rights and allows legislation of the kind that Australia's adopted to be valid within the international trading system.
Okay. Now, the Public Health Association made that comment and additional comments about potential restrictions on dealing in public health with alcohol and obesity and implications or arising from, free trade agreements. Is that an area of concern for you that you have noticed?
It is a matter of concern to us because we have the global trading system does have particular exemptions which would protect these health interests. But we have a range of free trade agreements and bilateral investment agreements that do not. And I think that is one reason why we think that consideration of human rights or health issues should be right up front at the primary level of negotiating the treaty and considered as part of the national interest analysis rather than at the secondary level when legislation may be introduced to give an implementation to that treaty. But as you will know, many human rights treaties that involve health matters are not implemented in Australian domestic law and do not come before Parliament other than at that primary stage of the treaty ratification process.
Thank you. Senator McEwen.
Thank you. Thank you, Professor Triggs, for your submission and your evidence. Just going back to your comments there about the national interest analysis. So I take your point that there's no human rights clauses in trade agreements that Australia is currently negotiating. Is the Human Rights Commission consulted as a part of the national interest analysis with respect to human rights currently?
My understanding is that the answer is no. We are not consulted. If we can see something coming up that we think raises a human rights issue, we would certainly contact the Attorney General's Department and possibly DFAT, but we are not consulted as a matter of course.
Are there any aspects of, for example, CHAFTA or the TPP that you've indicated your concern about to those forums, to either the Attorney General or DFAT?
We haven't as yet, but the Trans-Pacific Agreement or negotiations are sort of in play at the moment, and we've really waited to see what kind of definitive provisions are going to be there, but we haven't made a submission directly to them on this question, but we would certainly think it's very important indeed that there be a social or human rights clause included.
Right. Would the Human Rights Commission typically have access to the content of the agreements in the negotiation stage?
No, we do not.
Have you ever asked?
I think historically we might have done in relation to attempts, for example, some 15 years ago, I think now, with the attempt to create a multilateral, transnational corporate a treaty where there was no protection for human rights, and I believe the Commission may then have asked to be better informed about the process. But as that attempt failed, primarily because it did not protect social interests and human rights interests, the matter was not taken forward. But generally the answer is we are not consulted, and we do not know the clauses that are being debated, and therefore it's difficult for us to make a useful contribution.
All right, thank you. Now, I note in your submission you indicate that there could potentially be a role for the Parliamentary Joint Committee on Human Rights as an oversight body. Is that right?
Yes, it is. And the reason is that, as you'll be aware, that body has been operating now for the last 3 years. Mm-hmm. It's really been, in our view, or in our respectful view, increasingly effective, in the sense that it's become more familiar with the treaty processes and the implication of treaties, and with human rights, 7 human rights treaties that they deal with. And we feel that they've got a growing competence, along with the support from their Secretariat, and it would be very intelligent to raise this, the relevance of what we call the Scrutiny Committee, the Joint Parliamentary Committee on Human Rights, to play a more integrated role with the national interest analysis and with the Department of Foreign Affairs negotiating these arrangements.
So you don't think that role would come too late in the negotiation process?
Well, we suggest that they have the role much earlier at the primary process. In other words, if it were possible to have a human rights inclusion in the national interest analysis, then we would suggest engaging the Joint Parliamentary Committee on Human Rights in that process at the earliest stage, because so much expertise has already been developed by them that they could be very efficient in working jointly with J. Scott.
All right, thank you. And finally from me, the previous witness was the ACTU, and Mr Detmer made the comment that international treaties were first used basically to prevent war between nations or to bring peace between nations, but that over time they're increasingly used for sort of quasi-legislative reasons, dealing with issues including trade and services and other aspects of what would normally be contemplated under federal legislation, domestic legislation. Do you have a comment about that, just in terms of helping the committee understand the changes in content of treaties?
Well, I think it's fair comment to say that the multilateral treaties internationally have initially been primarily concerned to ensure peace and to manage conflict. But of course, if you look right back to the 14th, 15th centuries of the city-state, most of those bilateral agreements were actually trade and/or safe passage for ambassadors. The law of diplomacy, the law of the sea were the formative treaties of the Middle Ages, and moving into trade treaties in the 18th, 19th, and 20th centuries. So it's been a very, very long process developing the content. But I think probably the point that's really made is that post the Second World War, there's been a huge development of international human rights law, but equally many thousands of treaties negotiated bilaterally, regionally and multilaterally to cope with trade. And I take the point that it's become sort of a form of lawmaking for the international community, subject, of course, to the agreement of each nation state. So sovereignty is preserved, but nonetheless, because of the globalization of trade on issues like health and tobacco control or disease, managing sea lane traffic, managing dangerous items like nuclear goods, we must engage multilaterally to deal with what are now cross-border, transnational and global problems. And that's been the development, a massive development since the 50s in regulating the international legal environment.
Can I just have one more question? In that context then, Professor Triggs, what about the increasing involvement of multinational and international corporations in treaty-making process and treaty enforcement? Have you got any comments about the developments in that sphere in recent history?
Well, that's a fascinating area of relatively recent development, because international law and international treaties are developed only to regulate the relations between states. But you will know that with the end of the Second World War, we had the development of individual responsibility for war crimes, and that was developed from Nuremberg, but now with the Rome Statute ratified by Australia, creating individual responsibility for egregious breaches of international criminal law. And what was followed from that too has been a belief and development of responsibility of transnational corporations who previously were not subjects of international law, only states were. But we now find a significant growth of responsibility for transnational corporations, particularly through the United Nations and Professor Ruggi's work, and the development of voluntary compacts like the Global Compact on Social Responsibilities and Human Rights and Labour Law and so on. So what's been happening, particularly in the last 20 years, has been a quite dramatic growth in the responsibility of transnational corporations for their actions. It might be environment, it might be trade, or it might be human rights and health. But that is one of the most important and recent developments in international law, particularly trade law. And of course, we've seen recently a much greater interest in regulating the transfer of capital and profit for the purposes of taxation regimes. And that really is perhaps the next major issue where we engage transnational corporations, which of course have turnovers which are greater than overwhelming majority of states. So the balance of power, if you like, has changed significantly in the last 40 years.
Thank you.
Thanks, Chair. Professor Triggs, good morning. Can I take you to your paragraph 38 and then 41? You're referring to the UN recommending the standing national reporting and coordination mechanism be established, and then in your paragraph 41 you actually make that recommendation. Could you just give the committee your advice as to how you feel that particular mechanism would be structured? Would it require the establishment of a new entity, or do you think there's an existing entity that could actually take that role on?
Well, we've suggested in paragraph 40 that the way the spirit of this recommendation might be adopted is to create an interdepartmental committee approach with terms of reference that determine the role of that body. It would certainly be a much more efficient way of coordinating the reporting, and partly because although they report different departmental bodies are dealing with different treaties, the substantive Australian provisions in relation to them often overlap. They're simply duplicated. And it becomes an extremely cumbersome process to do it the way we're doing it at the moment. So we suggest that it doesn't have to be particularly complex in legal terms, but could be simply the creation of an interdepartmental committee and perhaps some minor amendments to the, for example, to the scrutiny committee provisions to engage them in the process. But it wouldn't be difficult to do.
And how would it stand the criticism if it was interdepartmental? How would it then stand the criticism that just says it's another agency of government or agencies of government advising government?
Well, I think that were I required to justify that in the public arena, I would say that it's actually reducing the work of three departments, a component within three departments, and reducing it to one committee. So I'd say that it's actually consistent with government policy in achieving efficiencies and reducing the work across three departments into just one interdepartmental committee.
And to whom would it report? To Cabinet, to the Joint Standing Committee, to this committee? Who would the interdepartmental committee actually have accountability?
I would it would be sensible to go to JSCOT, for the Joint Parliamentary Committee on Treaties. I think would be the obvious one, because it's a treaty monitoring body, and we see the reporting function as being part of the treaty obligations that Australia has accepted under those treaties.
So it would be relate generically to treaty making rather than to any specific negotiations that are on foot at any time. Is that how I understand your recommendation to be?
I think so, in the sense that the view in the international community, or certainly through the UN human rights monitoring processes, is that the reporting processes under those 7 treaties is part of the implementation of the treaties in domestic law. And so it makes sense to include it within the JSCOT responsibilities, but and the reason perhaps we favour that would be that that's at the primary level rather than at the secondary level when we're dealing with the question of whether or not legislation is introduced, because as you know, legislation is not always introduced to give effect to our obligations internationally. That's
correct. Thank you. Thanks, Chair. Thanks.
Senator Whish-Wilson to take us through to the break.
Professor Triggs, are you aware of any human rights or significant human rights issues within the countries negotiating the TPP?
To be honest, I haven't been privy to those negotiations, and I don't know. Given the negotiating states, and as you know, an extremely complex process, many of those states, including the United States, will probably be looking for social and human rights clause. So I was hoping that they would be wanting to include one. But I know that Australia has taken a policy position not to include a clause of that kind. But as I've suggested in relation to the plain packaging litigation, that could very well be a mistake for the future. But to answer your precise question, no, I haven't been included in those discussions. I don't know the terms, and I haven't got a specific issue that I could raise.
So I suppose my question was more generic. I mean, there's 12 countries involved in the TPP. Is there any particular countries that, putting the negotiations aside, that you have issues with in terms of human rights abuses? And countries, for example, Brunei and Vietnam, are there issues that the committee should know about that haven't been incorporated as an example in what you're talking about today?
Well, one of the recent concerns we've got is that Brunei and Vietnam, but most particularly Vietnam, employ the death penalty rigorously. And if I remember correctly, Vietnam executed 40. Very serious matter. Hello.
Yeah, sorry, I think we lost you there, Professor Triggs. Could you just repeat the last last part of that sentence?
Yes, well, one issue that comes to mind immediately because of the current recent situation in Indonesia is that Vietnam and Brunei retain the death penalty, and Vietnam has executed 44 people last year. Now, I think that, just perhaps in parenthesis a little, that this might be an opportunity for Australia to take a leadership position in arguing for at least a moratorium on the death penalty in the region. But I think it's something that should be part of the Trans-Pacific Partnership negotiations.
Okay, and look, just lastly, in your submission, you've said under national interest analysis and human right analysis, the Commission congratulates the Australian Government for its continued support of the treaty-making reform process commenced in 1996. You talk about the national interest analysis and the establishment of JSCOT. We heard the weight of evidence yesterday was that those reforms aren't really adding to the democratic process around trade agreements because the executive still has too much power and these deals are politicised. Do you have any comment in relation to that?
Well, I've been, of course, watching this throughout my career, the last many decades, and I think that the JSCOT and national interest analysis process that emerged from the Trickle Treaty report has been extremely valuable. So I think that's got to be the first point. But the second point is that it arose out of the sense that there was no transparency and that it was entirely a matter for the executive. So I think where we've come to in the last few years has been a very significant advance on the past. But of course, we're thinking about the future. And I think that it needs to be strengthened, the engagement of the public or engagement with appropriate stakeholders needs definitely to be strengthened. I think that's been one of the criticisms, that it hasn't been as transparent as it should be, or there's not enough resources given to JSCOT to engage the Australian public in the process. I think I feel about this quite strongly in the sense that the Australian public understands so little about our treaties. Where, of course, from the point of view of the Australian Human Rights Commission, we're dealing with, our mandate is to deal with human rights treaties that have never been implemented into Australian law. And that creates enormous confusion in the public mind that when I, as President, say something Australia has done is in breach of international law, the Minister or the Secretary of the Department can say, well, that's all very well, but Australian law is to the contrary. And that is something the Australian public simply doesn't understand. And I think they need to be much more closely engaged with the negotiation and consultation process than they are at the moment. So I would accept the criticism or comments made by others, but acknowledging that we've come a very long way over the last 20 years or so.
Thank you.
Well, thanks very much, Professor Triggs and Dr. Potts, for your submission and evidence, and we will now suspend for 15 minutes.